Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 16th, 2022. The time is 9:30 a.m. Joining us today are Commissioner Janeka at the dais, and Commissioner Lindley is joining us virtually. Good morning to you both. We're also joined by our General Counsel, Ms. Smith, and I am John Neerman. For those of you who are joining us virtually, please keep your microphones muted when you're not speaking. For those making presentations, please wait to begin until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item that you'd like to comment on, and we will do our best to accommodate that request. So with that, I'd like to thank everyone for joining us, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of a motion for rehearing regarding the Commission's issuance of a default order in the matter of an enforcement action concerning Ann Riddlehuber. The movant should speak first, followed by the applicant, the ED, and OPIC in that order. OGC provided notice that each party will have 5 minutes of oral argument time, and the movant may reserve time for rebuttal as she bears the burden of proof. And I believe we can start with the movant. Mr. Gregg is here for the movant.
Good morning, sir. I'll have you just double check, make sure you've got a green light on that microphone. You may have to push the push button.
Green light, if y'all can hear me fine.
Yeah, you're coming in loud and clear.
Too loud, it sounds like.
No, you're great. Yeah, when you're ready, sir, go ahead.
I am ready. Good morning, Chairman, Commissioners, General Counsel. My name is Peter Gregg, Counsel for Madison Riddlehuber, who is the daughter and legal guardian for Ann Riddlehuber, the recipient of this enforcement action. As stated in the pleadings presented to you, we're here really on one issue, whether the notice leading to the enforcement action was sufficient. And we offer to you that it was not sufficient from a legal standpoint, but certainly from an equitable standpoint. And I just want to take a minute or two to flesh that out. Ms. Riddlehuber has dementia. We presented that to the Commission. We presented confirmation of her dementia to the Commission through medical records. To the extent that she was sent notice, she was not in a mental capacity to receive the notice, understand the notice, and react to the notice. So to the extent that she received it, it effectively was not anything she could have acted on. When this was going on, she was either under the care of a third-party provider in her own home, or she had been moved to an assisted living because of the dementia. Unfortunately, some of this was happening during the gap in time when the family was putting together the protections around her living condition. Now that her family has become aware of the circumstances, particularly Madison Huber, the daughter, she has jumped on this. She first retained elder law counsel and subsequently me to work with staff to see if we couldn't get this resolved amicably. So that's why I'm here, is asking for, on behalf of both Madison and Ann Riddlehuber, some consideration from the commissioners to return this to staff for further consideration, discussion with staff. We've had some talks with staff. They've been very productive, and so we look forward to working further with them to the extent that's the desire of the Commission. And with that, I'll reserve the rest of my time. Thank you.
Thank you, Mr. Gregg. Colleagues, any questions? Seeing none, let's hear next from the Executive Director, staff.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Taylor Pearson. I'm an attorney with Litigation Division representing the Executive Director. The underlying default order issued against Ann Riddlehuber was approved at agenda on August 24th, 2022, and involves a formal metal plating facility. While the ED attempted to communicate with Ms. Riddlehuber several times, for the first communication the ED received from Ms. Riddlehuber was Madison Riddlehuber's motion for rehearing on September 7th, 2022, stating that Ms. Riddlehuber is mentally incapacitated and living in an assisted living facility. The executive director filed a response opposing the motion because it did not meet the rule requirements for such motions. However, because Madison Riddlehuber's subsequent reply and amended motion with supporting documentation shows that prior to the filing of the amended petition, the property was sold and respondent was mentally incapacitated, the ED does not oppose the motion for rehearing. Thank you.
Thank you, Mr. Pearson. Colleagues, any questions for Mr. Pearson? Seeing none, let's hear next from OPIC. Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and Staff. For the record, I'm Jennifer Jameson with the Office of Public Interest Counsel. As outlined in our brief, OPIC finds that respondent's motion does establish a reasonable basis for rehearing consistent with the requirements of Texas Government Code Section 2001.146 and Texas Admin Code Section 80.272. As such, OPIC recommends the Commission grant the pending motion to set aside default order and remand this to the Executive Director. Thank you.
Colleagues, I agree with that. I think the Move-Ins Council had it correct when he talked about the equities of this case, and I'm ready to grant the motion. Commissioner Lindley?
I'm in agreement.
Commissioner Janeka?
Likewise, I too am in agreement.
I believe we're ready for a motion.
Well,
I'm prepared to make that.
I can move. Oh, go ahead.
I move that we grant the motion for a hearing filed by Madison Riddlehuber on September 7th, 2022, set aside the Commission's default order, and remand this matter to the Executive Director to allow the respondent an opportunity to file an answer by December 6th, 2022.
I second.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the proposal for decision and proposed order concerning an application by Van Ruyten Dairy Partners for a major amendment and renewal of Texas Pollutant Discharge Elimination System Permit number WQ00032900000. The order of presentation should begin with the applicant, followed by protestant, the ED, and OPIC. The parties have been notified that they will each have 5 minutes of oral argument time. The applicant may reserve time for rebuttal as it bears the burden of proof. So we'll begin with the applicant.
And I believe that may be Mr. Bradbury for the applicant, or perhaps.
Yes, good morning.
Good morning, sir. Go ahead.
Yes, thank you. Good morning, Mr. Chairman and Commissioners. Jim Bradbury on behalf of the applicant, Van Ruyten Dairy Partners. Commissioners, this is a 229-acre dairy farm in Erath County, Texas, that permitted for 990 head, but they operate with about 741 head. This was a major amendment, but it didn't include any head count increase. It was primarily for rearrangement of land management units, adding a little area to the property. A barn, a water well permit, and then reconfiguring some drainage areas. Regarding that, the commission submitted 3 issues for the contested case hearing, and then Judge Henderson and Ciano took jurisdiction of that hearing. This dairy was in existence at the time before Van Ruyten Dairy Partners purchased it due to the death of the prior owner. They took it over and found that the facility had been not well maintained and had been subject to some prior orders from the agency. So they spent an exorbitant amount of money to remove manure, sludge, and other from the facility to bring it up to current compliance. At the hearing, the only issue that both judges had determined that issues 1 and issues 3, the protestant had failed to meet her burden of coming forward with some evidence that there was a state or federal issue that the draft permit violated. And so the only issue at the hearing was regarding the possibility of nuisance conditions We had a hearing for a day. Multiple witnesses testified for applicant, ED, and then the protestant. One protestant testified on behalf of herself. The other protestant did not show at the hearing. But ultimately, the determination following post-hearing briefing to the administrative law judges is that the protestant had failed to meet her burden to demonstrate that the permit would violate any state or federal requirement regarding nuisance conditions. And the PFD itself, the judges did a good job and identified 18 separate areas in this draft permit that are directed to controlling nuisance conditions. In addition, there are multiple places in this permit where special provisions are written in for best management practices of the manure. One, in fact, is, the prior facility was just simply, they scraped the manure, piled it up, and hauled it off, but the Van Rootens purchased a vacuum unit such that multiple times a day, they're going down with a vacuum unit to pick up that manure and hold it. So to summarize just for this, the PFD was issued. There were no exceptions filed by any party. At the conclusion of the hearing, all parties except for protestant agreed the permit should be issued. So that's what we're asking from the commission today.
Thank you, Mr. Bradbury. Colleagues, any questions for Mr. Bradbury? All right, let's hear next from the protestants. Good morning, Ms. Wharton.
I'm not a lawyer, I'm just a grandmother here trying to save my home, so
Well,
please be
we are
patient with
glad
me.
you're here, of course, yes.
Okay, so thank you for this opportunity to come before you today. I am here today asking this commission for my life and the enjoyment of my property back, okay? The information provided to you from the SOA hearing is only a small fragment of the evidence that I have prepared. And the reason for this is the evidence is not there because SOA informed me on the Thursday prior to the tentative hearing that this case was not on the docket, okay? So I was called by TCEQ Monday morning saying, are you coming to the hearing? So both judges were notified immediately when I appeared at the hearing that I had been informed by their office that the hearing was not on the docket. So as you can imagine, not being a lawyer or familiar with legal terms or laws, I was at a great disadvantage when I was misinformed by SOA, okay?
And Ms. Borden, if the evidence wasn't presented at the SOA hearing because of the laws regarding these kinds of hearings, the commissioners will not be able to consider that today.
Consider what?
Any kind of evidence that was not considered by the SOA judge. So if
Okay,
it was
it's on the document. You talking about my posters?
anything, you mentioned that you had additional information perhaps that you weren't able to present to the SOA judges?
No, everything I've got is already in your SOA documents. I'm just saying, you don't have all of the information I collected because the SOA told me that this case was not on the docket. So when I was called, I was in my pajamas drinking coffee.
And Ms. Wharton, your intention is not to produce new evidence today, but just to simply point out that there was a notice issue.
Well, yeah. Yeah, otherwise you would have a whole lot
Right,
more evidence than
right.
you have now.
I got you.
Does that
I
make
think we're
sense?
good.
Okay.
Yeah.
All right.
Sorry to interrupt you. Go ahead.
Yeah, no worries. The changes in this permit have already taken place, okay? And they were done before the neighbors ever got notice, okay? And the verbiage on the agenda today has also been changed, and it was not on the original documents as far as the addition of the words "and renewal." These are not on the original documents. So in the response by the ED to public comment, comment number 1 specifically addresses health concerns. And the response was, if rules are followed, should prevent health concerns. Well, on August 30th, I died. That is new information as a result of the pollution from this facility. I've been in my home 32 years. We have over 70 years of history living next to a facility. But because of the pollutants at my house, I was put on life support, okay? Comment number 4 mentions eye infections, which I've often had because of the flies. My problem is flies, okay? And the response is, let's see, if the things in the permit, the BMP, the NMP, the PPPs are followed, it should prevent this stuff. Well, hello, it's not working, okay? And there's not enough time for me to quote the laws that protect the public from nuisances and pollutions. The executive director's response in that letter is the fact that call the local authorities. Well, the local authorities have been called multiple times. They said there is no violation, and they will not do anything. They said there's nothing they can do. So there's no enforcement, okay? This particular picture here is in the SOA notes. There's 194 flies, 194 on the visible portion of the car. This photo is taken 1 hour later, 0 flies, 0, 1 hour later, okay, because it was taken in town. This picture is in your documents. This is what happens when I open the windows to my home. That is not normal. The windows in my home have not been opened in over a year because of this fly infestation. This is my world. Inches daily of flies is what I deal with. 3 inches daily, okay? Now, my story is so friggin' unbelievable, I had to bring evidence because no one is listening, okay? And I'm a prisoner in my own home when I'm not evacuating. Again, I'm asking you for my life. I have not been able to touch my dogs. They're sick, they're losing weight. This is a travesty that I've been in my home for 32 years, and I've been run out by somebody who's expanding. Please, I'm begging you. I would like my life back. I would like to stay in my own home. Thank you.
Thank you, Ms. Warden. I do have one question. Could you give me a sense of sort of the timeline and calendar? When did these problems begin for you?
About March and April, well, let's see, of 2021. There's been a facility over there for 30 years. You have never heard from me. You have never heard from my neighbor. Between the two of us, we have over 70 years of living next to a facility. And this, I don't know what they're doing, but I know 2 entomologists have been out to my place. They have stated, get rid of the source. The source is manure and trash, 2 things of which I do not have on my place.
Thank you, Ms. Warden. Colleagues, any questions?
I'm curious, Ms. Warden, what about the request from the facility and the recent actions do you consider an expansion of their activities? How is the impact changing, or how do you? I just want to understand how you consider. What about it resembles an expansion to you, because the request doesn't seek to alter the maximum number of cattle authorized?
Correct, but they have increased the area in which they can apply manure, which is actually right up against my fence line.
Got it.
Okay, they put manure right up against my fence line on my property. And then they've changed the facilities. Now, as far as the vacuum system concerned, vacuums have exhausts. And it's a well-known fact studied by immunologists that dairies emit an allergen called BOSD2 that causes anaphylactic reactions in asthma patients and exacerbates asthma symptoms. That was a study done by the Immunologists and Asthma Association.
Ms. Warden, did you testify to that at the hearing?
I did not have that information because I hadn't died yet.
I would caution the commissioners then that is information that shouldn't be considered today.
Commissioner Janeka, any other questions?
Thank you.
Commissioner Lindley, any questions? All right. Let's hear next from the executive director's staff. And good morning, Mr. Parr. I'll ask you if you have something to say about it. Ms. Wharton raised a question about notice, and if you have any information about that, I'd be interested in hearing that as well.
Good morning, Chairman, Commissioners, General Counsel, OPIC. My name is Michael Parr with the Environmental Law Division. With me today are Joy Alabi and Greg Easley of the Water Quality Division. As to the notice issue, at the hearing when it started, Ms. Warden may have mentioned it, but it wasn't an issue fleshed out by her or with the ALJ to where the ALJ had any type of a substantive response. It was, I didn't get notice of the hearing and it started, so the issue wasn't developed more than what Ms. Warden claims.
Thank you.
So, for this matter, as Mr. Bradbury spoke earlier, 2 of the referred issues were dismissed on summary disposition before the hearing. The only issue at hearing was whether the draft permit prevents odor or nuisance conditions such as odor and flies. By introduction of the administrative record, the draft permit is a prima facie demonstration that the draft permit meets all rules and regulations and that the applicant has met its burden to supply application information that will allow the draft permit to operate as it's drafted. During the hearing, the protestants did not offer any evidence to rebut that prima facie demonstration. She did talk or discuss in great detail about the flies, but Ms. Warden was never able to tie the flies to the draft permit or any error or flaw in the draft permit for preventing flies and nuisance odor conditions. Therefore, the ALJ agrees with the ALJ's PFD as drafted, which calls for the permit issuance, and we are available if you have any questions beyond what I've said.
Thank you, Mr. Parr. I have none. Colleagues, any questions? Commissioner Janeka?
Not at this time.
Commissioner Lindley?
No, thank you.
Okay, let's hear next from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and Staff. For the record, I'm Jennifer Jameson with the Office of Public Interest Counsel. Before I begin, I just wanted to point out that OPIC was aware and spoke to Ms. Warden about the notice issue, and there was a standing schedule that had the date of the hearing on our procedural schedule that was agreed to by all parties. However, I do think that prior to the hearing, it was discussed with the ALJ that she did make a call and did receive false information from someone at SOA that the hearing was not on the correct date. So I just wanted to put that on the record as I witnessed that.
Thank you.
That said, OPIC does agree with the positions taken by the administrative law judges and supports issuance of this permit without modification. As outlined in our closing brief, OPIC notes that 2 of the 3 referred issues were disposed of by the ALJs via summary disposition, leaving the prevention of nuisance conditions, including odors and flies, as the only issue to be litigated in this case. OPIC agrees with the ALJ's finding that the weight of the evidence demonstrates that, if followed, the draft permit, the TCQ rules, and the practices and management activities adopted by applicants should prevent the dairy from causing odor and degradation of air quality. Further, OPIC agrees with the ALJ's finding that protestants' concerns and evidence bear more on whether the dairy is being operated according to the permit requirements and not whether the permit itself meets all requirements. That said, OPIC is sensitive to protestants' concerns regarding an increase in odors and flies on their properties and would like to reiterate that we will remain a resource to Ms. Warden and all members of the public regarding permitting and enforcement procedures and processes. In sum, OPIC finds that the draft permit is consistent with the applicable law, agency rules, policy, and practices, and therefore OPIC agrees with the ALJ's conclusions and analysis in support and issuance of this permit. Thank you. I'm available for questions.
Thank you, Ms. Jameson. I have none. Colleagues, any questions? Commissioner Janeka?
Not for OPIC at this time. Thanks.
Commissioner Lindley?
No, thank you.
Okay, and Mr. Bradbury, you have some rebuttal time left.
I'll be very brief. Thank you, commissioners. First off, as you all know, this is an individual permit, which is the strictest permit that the agency issues to animal ag facilities in the state. It was highly developed over many, many years and approved by EPA. In addition, this dairy is located in the North Bosque area, which is subject to even stricter rules applicable to dairy facilities in that area that are not applicable to other facilities. So the rules, requirements that go into this permit are frankly the most stringent that we have in the state. This permit was thoroughly prepared, thoroughly reviewed, and the subject of a lot of discussion and testimony at the hearing. Just briefly concur with the general counsel, and I realize you all know that, and I didn't want to object while Ms. Warden was speaking, but both today as well as previously, we've had great difficulties with Ms. Warden injecting things that are not properly in the record, so I just note that objection for your consideration. But all of these issues were well discussed at the hearing. Ms. Warden, notwithstanding her statement that she's not a lawyer, did an able job of cross-examining expert witnesses, the agency witnesses, as well as the applicant at the hearing on all of these issues. So they were all before Judges Ciano and Judge Henderson that they came out with the PFD, that they fully considered those issues. Lastly, with respect to the notice issue, I just want to make clear that the judges were sensitive to that. The hearing was set at a preliminary hearing well in advance of the hearing itself. Everyone was agreed to the date. There was a written schedule, a notification of the actual date, and then at the time Ms. Warden said that she'd gotten incorrect information, the judges asked her if she was prepared to proceed, and she said she was. So we went ahead and conducted an extensive and lengthy hearing with full cross-examination there at the hearing. So I don't think that there is really any issue regarding due process or otherwise with the notice, because we did have a complete hearing and vetting of these issues. So with that, I'd ask the commissioners to approve the PFD, findings of fact, conclusions of law, and issue the permit.
Thank you, Mr. Bradbury. So colleagues, here's where I am with this. As to the notice issue, I believe notice was proper. It sounds like Ms. Warden may have gotten some bad information, but that didn't create a legal notice defect, a due process issue in my mind. On the merits, the substance of the argument, I don't have a basis to change the ALJ's evaluation of the evidence. I think the only truly contested issue, as we heard, was on nuisance, particularly with respect to flies, and that the evidence in the ALJ's weighing of that evidence was in the applicant's favor. So I agree with the executive director, OPIC, and the ALJs that we should adopt this order and issue the permit. I appreciate, Ms. Warden, you being here today. I have heard your testimony. I'm very sympathetic to the situation that you're enduring, and you know, I appreciate the frustration that you have with that if-should construct you spoke about. If the applicant does what the permit requires, then it should be protective. That's a hard thing to swallow when you live next to a facility that you believe is causing you problems, but it's really kind of in a way, at the heart of what a permit is. A permit imposes legal requirements on an operator that if they follow those requirements, the permit is protective. And so then it moves from a permitting question, if that doesn't happen, then it becomes an enforcement question. I don't know if that's helpful at all, but our investigators are certainly available to help you with issues as well. And so those are my thoughts, colleagues, on the issue. Commissioner Lindley, what are your thoughts?
I completely agree with all your comments. I thought they were very well said. I don't have any additional thoughts.
Commissioner Janeka.
I wonder if I might be able to return to Executive Director staff and ask a couple short questions.
Of course.
I've taken a moment to pull up the underlying permit, and I appreciate Ms. Wharton coming before us, and frankly, at this point, I'm in agreement fully with you and Commissioner Lindley as well, and I'm prepared to move forward, but frankly, that's not good enough, where we're leaving this issue in the eyes of the public, and in response to Ms. Wharton's ask today. And so I think the only answer is to look at the permit enforceability and to ask, what are, I would just invite a comment from Edie to speak to the complaints and conditions that Ms. Wharton observed, alleging that it's begun early 2021 inside of that window. That's not, I appreciate that. I will merely do this. I'll invite Ms. Wharton to contact my office and ED staff. I'll ask you to come sit down with me and brief me later. And perhaps these are, considering it's an enforcement-related discussion, it may be an issue that I'll ask Ms. Kyle, my office attorney, to take lead and visit and coordinate to make sure that there's no misunderstanding about how enforcement and compliance for this permit moving forward for any events and occurrences that occur into the future, that there's no question on Ms. Wharton's mind how to address those, how to address and point to what she believes the deficiency in the compliance with that permit to be, so that our enforcement staff can help answer any questions she has moving forward. I'll leave it there. Thanks.
Thank you, Commissioner. Do we have a motion?
I have a motion, yes. I would move that we adopt the administrative law judge's proposed order, that we issue the major amendment and renewal of TPDES permit number WQ000329000 to Van Rooten Dare Partners as recommended by the executive director, and that we adopt the ED's response to comments.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the proposal for decision and proposed order concerning the application by Air W 2017-7 LP for new Texas Pollutant Discharge Elimination System permit number WQ 001-5878001. The parties have been notified that the applicant and the protestant, the City of Georgetown, will each have 10 minutes of oral argument time, while Jonah Water Special Utility District, the ED, and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal, as the applicant bears the burden of proof in this matter. And I believe we have Helen Gilbert here for the applicant.
Good morning, Ms. Gilbert.
Good morning. Good morning, Chairman, Commissioners, General Counsel. I'm Helen Gilbert on behalf of applicant Air W 2017-7 LP. This is the second time in the last 2 years that I've addressed you on the issue of regionalization, the primary issue of regionalization in a TPDES permitting case. By my count, this issue has come before you at least 5 times since 2017, when the legislature stripped cities of their authority to forcibly annex. with more cases, I think, percolating through the hearing system now. I'm pointing this out because cities, some cities, not all cities, have successfully hijacked the hearing process to force annexation on developments in their ETJs. That is especially true in this case with Georgetown. The good news is that in each of these cases, the ED, OPIC, the ALJs, and yourselves have all correctly interpreted the state's regionalization policy as a permissive goal to encourage and promote regionalization, not as a barrier or a cudgel to force service on unwilling customers. In each case, the TPDS permits have been issued, and you have never denied a permit solely on the basis of regionalization. I urge you to follow that lead here. More good news still is that you've given the regulated community clear guidance on how to interpret regionalization in TPDS permitting cases. That's through your web page policy. That guidance was announced after the Crystal Clear case and after your denial of the City of San Marcos's rulemaking petition. Although Georgetown is highly critical of your web page policy, they urge new interpretations, very narrow interpretations, and unreasonable methods of regionalization. This is the most recently announced policy, and it's the confirmed policy of this commission. The ALJs correctly applied it. They stated that TCEQ has significant discretion under the statute, particularly in determining reasonable methods to use to further regionalization. It's important to note that this case closely follows the Crystal Clear case. You also have here a large special utility district, that's Jonah, that's planning to own and operate the wastewater treatment plant. It's ready, willing, and able to serve the proposed development. The cost of city service is much, much higher and more time-consuming as well. As in the Crystal Clear case, we absolutely agree with the ALJs that service by Jonah will further regionalization. The critical difference between this case and Crystal Clear, and I would submit to you, it's the determinative difference, is that the City of Georgetown has no legal right to serve most of the development. That's because it's within the Jonah's jurisdictional boundaries. Jonah has been very clear that it does not consent to the City of Georgetown's service within its district boundaries. To state this another way, even if Georgetown were correct on all the issues, and we maintain vigorously that they are wrong, the city is legally barred from providing service to the AirW development. On the issue of denial of service, we believe Georgetown's words speak for themselves. On page 9 of our reply to the exceptions in the slide, there's no question that Georgetown denied applicant service. As you can see, there are 5 different quotes by 4 different city staff who couldn't have been clearer that Georgetown would not serve applicant without involuntary annexation. Annexation is the effective denial of service. It is not a mere service condition like a tap fee. I also want to direct your attention to page 11 of the brief and the next slide. That shows what happens when the applicant is forced to get service from the city, which already cost $20 million on top of the construction of a plant. Receiving sewer service from Georgetown means annexation, which in turn means land use restrictions. That's represented by this exhibit, which is in the record at Exhibit 35, and the big pink dot. The dot is what it looks like when the city enforces its land use restrictions on the site. It requires 80% non-residential use or community centers. So, what is an unreasonable method of regionalization? it's forcing a developer to build 80% of what they don't build. It's really the death penalty for this development, Mansions Lux, which is 100% residential duplex community. Of the 7 other issues that were referred, applicant proved it's burdened by a preponderance of the evidence. Georgetown did not rebut our prima facie case. It pointed to exactly 0 draft permit provisions that violate state or federal requirements. The scant evidence, and this was not a case about water quality, as you can tell. It was mostly a case about regionalization. The evidence they did put on, the ALJs referred to as unverified and conclusory. Much of the witnesses' testimony was based on preference and not the rules on the books. By contrast, applicants' experts have a combined 67 years of experience in over 150 wastewater applications. The permit limits in this permit are more strict than Georgetown's Dove Springs plant, which is the nearest plant. And the site's going to use almost 100% of the effluent in a vigorous reuse plan. So ARW requests that you adopt the PFD with the 2 non-substantive changes recommended by the ALJs. I'd like to reserve the rest of my time for rebuttal, and I'm happy to answer any questions you might have.
Thank you, Ms. Gilbert. Colleagues, any questions? Hearing none, thank you. I think we're going to hear from Jonah Water Special Utility District now. Good morning.
Good morning, Commissioners. My name is Kelsey Doherty, Counsel for Jonah Water Special Utility District. We are the retail water provider for the development and the site of the facility. I'm just here to answer any questions that you may have.
Thank you, Ms. Doherty. I don't have any. Colleagues, any questions for Jonah? No.
Okay,
Thank you. And let's hear next from protestants. Is it Mr. Falk?
Yes, it is.
Good morning, sir.
Good morning. Thank you all for your time today, and just let me know when I can begin.
Go ahead when you're ready.
Good morning, Commissioners. My name is Cody Falk with the law firm of Spencer Fain, and I'm here representing the City of Georgetown as protestants in this matter. Thank you for the opportunity to speak with you today on a matter not only relevant to Georgetown, but other similarly situated cities in Texas. Contrary to what applicants are stating, the city did rebut the applicant's prima facie case, and the record supports the decision to not adopt the PFD as drafted and to deny the permit. This case is about the integrity of the agency's TPDS permitting process and whether the process as played out in this case enables you as commissioners to fulfill your statutory mandate to protect water quality while encouraging wastewater regionalization, and especially in light of the fact that the submitted application contained false information and was incomplete. The City of Georgetown is not here to hijack the process, but to make sure that the process is being fulfilled as legislatively mandated. While there may be a temptation to allow this project to proceed considering the Commission's lack of clear regionalization criteria post-Regal, this is not the application that should be allowed to slide. Here, there is a perfectly reasonable and cheaper option obtaining service from the City of Georgetown, which avoids adding a new point source of pollution operated by an entity that wholly lacks any qualifications to do so. This case mirrors much of the Regal proceeding, which was not referenced by Ms. Gilbert, which related to the proposed development of a package plant in the outskirts of the city of San Marcos. There, you commissioners found that that Regal made numerous misrepresentations in answering regionalization-related questions in the permit application, including the following. Regal knew the city had a permitted system within a 3-mile radius of the proposed facility, and the city's system had the capacity and the willingness to accept Regal's proposed wastewater, but its application suggested no such facilities were in close proximity to the proposed residential development. The Commission also found that Regal did not, but should have provided a comparative cost analysis for obtaining service from San Marcos versus constructing a new facility. The Commission's discussion of the Regal case made abundantly clear that the lack of accurate answers in that application hobbled the agency's regionalization analysis. Commissioner Janeka expressed disappointment at the false answers. In addition, Chairman Neerman asked that staff, quote, reflect on how they could have approached this differently. Yet rather than taking these admonitions to heart, agency staff in this application not only failed to recognize that the same pattern of misrepresentation was being repeated by this applicant, they dismissed the importance of providing a complete and accurate application. In addition, they accepted unsupported claims of not cost, loss of future profits as substitutes for cost comparison data to support a post hoc rationalization of the decision to recommend granting the permit. Just as in Regal, the applicant here falsely answered no to the following question in their application. Does a permitted domestic wastewater treatment facility or a collection system located within 3 miles of the proposed facility currently have the capacity to accept or is willing to expand to accept the volume of wastewater proposed in this application? By falsely answering no to that, the applicant was able to avoid providing in its original submittal an analysis of expenditures required to connect to Georgetown. Only after receiving Georgetown's public comments did the ED staff ask the applicant to submit cost information, but the cost information that they received was non-responsive and purely speculative lost profit information and not actual cost to connect to City of Georgetown. The larger point here is that it was only during the hearing on the merits that the applicant provided relevant cost information via the direct testimony of its own expert witness. That testimony affirmatively established that the cost to receive service from Georgetown was less than the proposed package plant. Aware that service from Georgetown was cheaper, in responding to staff's request for cost information, the applicant resorted to smoke and mirrors and creative math. Knowing that annexation was a trigger word, the applicant in this case urged the commission to believe that if the city provides wastewater service, the developer of the project, not the owner of the plant, the developer of the project, will allegedly lose money when it flips the project after 15 years, solely because the city would require the project to be annexed into the city limits, thus subjecting the land to city's property taxes. All this information is speculative. To support their diminution in property value claim, applicant provided 2 letters claiming the development would be less profitable when it is sold if the development were annexed versus if it were not annexed. That is not a cost to connect, that is lost profits. It's not pipe in the ground, it's lost profits. The speculative lost profits were derived from a financial analysis that included the alarming $20 million figure touted in the applicant's letters. No other case that we have found involve the claim that the commissioners should consider diminished market value or lost profits in addressing regionalization and the cost to connect. Moreover, the commissioners have consistently held that the TCEQ has no jurisdiction over considering the effects of its decisions on property values. Yet the applicant wants the commission to consider just that. The application and lost profit letters failed to provide any of the relevant cost comparison information to allow the ED to evaluate whether an exception to the state's regionalization policy should be applied. But helpfully, during the contested case hearing, the applicant's own expert agreed that the cost of connecting the city's wastewater treatment system was cheaper than building the proposed package plant. Specifically, their expert witness testified the cost to connect the city's system would be about $284,000 less than the cost of constructing a new wastewater treatment plant. That is even before adding in Jonah Water's connection fees in the amount of $2.4 million. Given that it is cheaper to connect to the city's wastewater treatment system, the cost of service comparison does not support finding exception to regionalization. Having failed to provide relevant cost information, the application should have been declared incomplete from the beginning, and the ED should have asked for relevant information to evaluate regionalization. Instead, the only, quote, analysis the staff witness did regarding regionalization and how it is affected by annexation was to ask his supervisor, who stated annexation constituted a denial of service and gave the matter no further thought. The level of disinterest displayed by the staff in describing the evaluation of the costs of regionalization cannot be overstated. The ED staff and the ALJs in this case would ignore Regal and the lessons this commission has asked agency staff to take away from Regal about false and incomplete applications. The commission cannot let that stand in this case. Compounding all of this, Jonah Water to step into the shoes of the proposed plant owner-operator does not satisfy the state's regionalization policy. Even if Jonah Water had been added as an applicant to the application as required by the forms and the Commission's rules, the involvement of Jonah Water is not a form of regionalization. Jonah Water does not currently provide wastewater treatment services to anyone, not even to the customers in its own sewer CCN. Jonah Water has exactly one employee with a current wastewater treatment plant operator license. Jonah Water's flip-flopping from opposing the application to supporting the application is transparently self-serving and does not advance regionalization or enhance water quality. The ALJs erred by even allowing the application to proceed once Jonah became the contracted operator. The city repeatedly, at the hearing, urged the ALJs to dismiss the application, which should have been refiled with Jonah Sud and the real parties in interest, the residential property developers, as owners, as co-applicants. Without these parties as co-applicants, the application is substantially incomplete and inaccurate, as both owners and operators must apply for a TPDS permit under 30 TAC 305-43A. Despite applicant and Jonah's claims that the city of Georgetown cannot serve the development because of some statutory bar is inaccurate. Georgetown has a statutory right under the local government code to serve the subject property. Jonah and the applicant inexplicably cite to a PUC rule as regarding CCNs as some legal bar to the city serving the proposed development, ignoring the fact that the CCN rule does not control, as cities like Georgetown are authorized by statute to provide sewer service both within its city limits and the ETJ. As addressed throughout the city's briefing, the Commission staff's flawed regionalization analysis is just the tip of the iceberg. Even if the regionalization analysis was correct here, the permit should have been denied given the substantially inaccurate and incomplete information in the application. Given the applicant's failure to provide an application that was substantially complete and accurate, and the failure of the agency staff to investigate the nature of the affected waters and downstream uses, there is no reasonable assurance that the draft permit, in this case, contains conditions sufficient to ensure protection of water quality and existing uses of the receiving water consistent with state law, including the state's anti-DEG and regionalization policies. As such, the draft permit should be denied. Thank you, and I'm available to answer any questions you may have. Thank you.
Thank you, Mr. Falk. I have none at this point. Colleagues, any questions for Mr. Falk?
No, thanks.
Thank you.
All right, thank you. Let's hear next from the Executive Director staff.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Bobby Salehi with the Environmental Law Division. With me today are Feroz Vahora and Alfonso Martinez from the Water Quality Division. Executive Director staff reviewed AirW 2017's application for the new TPDS permit and drafted a permit based on that application that will protect human health and the environment. Regarding the 8 issues that the Commission referred to SOA, the Executive Director supports the Administrative Law Judge's conclusions for all 8 issues. The Executive Director recommends that the Commission grant the application and issue the draft permit with the correction provided in the Executive Director's exceptions to the proposal for decision. The Executive Director also reviewed the proposed order submitted by the Administrative Law Judges and recommends that the order be amended as discussed in the Executive Director's exceptions and Judge Ludustansky and D'Angelo's exceptions letter. Thank you, and we're available for any questions.
Thank you, Mr. Salehi. I have none. Colleagues, any questions? Seeing none. Mr. Wayne, good morning.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. With respect to the Commission's consideration of the proposal for decision and related record in this matter, after examining the evidence and argument presented, OPIC maintains the position taken in our closing brief that AirW's application should be granted. OPIC found that the applicant met its burden of proof on the 8 issues referred by the Commission for consideration at the hearing and agrees with the Administrative Law Judges that the draft permit should be issued without changes. Regarding the highly contested issue of regionalization, OPIC found that the applicant complied with the state's regionalization policy. Georgetown required annexation of the development and its agreement to certain land use restrictions before it would provide wastewater service to it, which essentially equated to a conditional offer of service. Because this offer of service was conditional, OPIC, like the ALJs, found that it was appropriate to consider cost and other relevant factors when considering regionalization. First, OPIC notes that although the annexation requirement could be waived, there was no evidence that Georgetown was willing to do so. It also appears that the cost associated with connecting to the city's system would be substantially higher than the cost of constructing the treatment plant. Finally, the applicant and Jonah Special Utility District have entered into an agreement where Jonah will own and operate the facility for the applicant. Because Jonah is a large service provider in the region and expects to provide wastewater services to nearby developments in the area, its ownership of the facility furthers the policy of regionalization. All of this supports the ALJ's finding that AirW has complied with the state's regionalization policy. With respect to the other issues, OPIC agrees with the ALJs that the evidence demonstrates that the application is substantially complete and accurate. It also shows that the permit itself is protective of human health, water quality, and the existing uses of the receiving waters. It complies with TCEQ's anti-degradation standards and nuisance odor requirements, and also contains sufficient operational requirements. Finally, AirW's compliance history presents no basis for denying or altering the permit. For these reasons, OPIC respectfully recommends adopting the ALJ's PFD, incorporating the 2 minor revisions discussed by the ALJs in their letter considering the parties' exceptions to the PFD, and issuing the draft permit as recommended by the PFD. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Colleagues, any questions? Seeing none. Ms. Gilbert, I think you've got some time left for rebuttal.
Could I ask how much time?
3 minutes.
I'm going to go ahead and address the 600-pound elephant in the room. I think the accusation of falsification, that's just offensive to us. I know that occurred in the Regal case. Council cherry picks that case among the 5 that I referred to earlier. 2005-052 of the Texas Government Code prohibits you from denying a permit application based on falsification unless the falsification is intentional. Carlos Rubenstein, a former commissioner at this agency, stated after repeated questioning that he had no evidence of intentional falsification of the application. I think this is really stems from a fundamental misunderstanding of the application process. The application contains something like 500 questions, 124 pages of instructions. As we well know, there are many parts of an application that don't apply to a TPDS permit of the kind proposed here. There are no wet limits, there's no sludge processing, there's no grit and grease trap removal. These are NA on the application. Applicant had every reasonable belief that it had been denied service on the repeated quotes by Georgetown staff from 2019 all the way through the hearing process. Repeated denials of service through the requirement of annexation. As to Jonah's qualifications, its general manager has a AA, which is way more than what they need. He's got 30 years in the wastewater treatment business. He even teaches at the Extension Service, has done so for 20 years. He has a 35-member staff. This again, hearing is not about water quality. It's not about qualifications of Jonah. Jonah has master plan. They're going to be serving a lot of people within their jurisdictional boundaries, and this is merely one of several developments. Regal was about easements and the availability of easements. I'd point out in the HK case, in the Regal case, in the Crystal Clear case, all those applicants calculated their costs differently. And 2 of the applicants didn't calculate costs at all because they were also denied service. So in the way that your agency has always approached this per the water quality permitting staff, if you've been reasonably denied service, you don't have to provide costs. But we went a step beyond that. We provided costs as a supplement to the application. We provided costs again as additional information under the post 709 process, 20347. And then there were several other issues. You remember the big pink dot that show there are all kinds of external costs that we didn't even calculate. There's no rule, by the way, no criteria on cost. So we can't create an ad hoc standard right now. I'm happy to answer any other questions you might have. It looks like I'm out of time.
Thank you, Ms. Gilbert. Colleagues, any comments or questions for anyone before we get going here? Okay. Commissioner Lindley?
Oh,
No.
no.
Okay. Since this word falsification came up, let me just address a personal preference. And if something is not true in your view of the facts, you could call it false, but the word false carries a lot of weight. It suggests that something is intentional, and sometimes things are intentionally false. So that word is appropriate in some context. Just for me personally, that sets off alarm bells for me, and I do look for intentional, knowing falsification. So maybe it's just an old-fashioned notion of politeness or an effort to keep things civil. I understand the pressures that attorneys are under, from their clients or whatever it may be, so I can understand why sometimes we reach for that word when it may not be the most appropriate word. But I would say, so not knowing more about the facts, I will not fault counsel for the use of it today, but I'm just expressing a personal preference and a note for anybody who wants to argue, at least before me, and be persuasive, that just to be sensitive about that word. Colleagues, I am generally satisfied with the ALJ's work here. The main issue, in my view, and clearly the council's view, is issue B, whether the draft permit is consistent with the state's regionalization policy. And I agree with the ALJs that the city's repeated condition of requiring voluntary annexation, especially because it came with land use implications, was effectively a denial of the applicant's request for service. I'm sensitive to some of the points that Mr. Falk made about the cost analysis, but I'm not sure that I even reached the cost analysis. It wasn't particularly persuasive one way or another for me. I will nitpick one part of the analysis, and I think Mr. Falk rightly picked up on at least part of this, and that is that I don't think that Jonah's regional water service is relevant to the issue of regionalization on wastewater service, nor do I see Jonah's potential future provision of regional wastewater service as having much relevance here. So I would propose that we simply strike findings of fact 53 and 54, which make those points. With respect to protectiveness of water quality and existing uses of the receiving waters, that's issue A. I don't see any evidence or argument that would change or that should change the ALJ's findings. The same goes for issue C about protectiveness of health of the nearby residents. Same for issue F, whether it complies with the anti-degradation policy. Issue H, whether the permit's provisions and operational requirements are sufficient to protect water quality. The same goes for issue D concerning nuisance. I agree with the ALJ's analysis regarding completeness of the application, and that includes completeness with respect to identifying the applicant, the buffer zones, floodplains, the adjacent landowner map. All of that's issue E. With respect to identifying Jonah as the owner or operator, I think it's important both that Jonah would not become the owner or operator until after a permit issues, but also important that when the application was filed, that arrangement with Jonah had not been contemplated. Similarly, with respect to issue G, the city invites us to require a review of Jonah's compliance history. Currently, there's no such requirement, and I would not adopt one here ad hoc. Didn't come up in argument. I don't see an issue with the transcript costs. I think the only other loose ends are the corrections suggested by the executive director on finding of fact 3 and by Jonah to finding of fact 51 that were agreed to by the ALJs, and I think we should make those amendments. So that's my analysis of this item. Commissioner Lindley.
I'm in complete agreement. I think it was a well-developed record, and other than the, deletion and the two other amendments of the finding of facts. I'm ready to move forward supporting the order.
Thank you, Commissioner Janeka.
Likewise, I'm in agreement across the board and appreciate you pointing out the points of Mr. Falk's argument that I agree with as well in terms of removing those two findings of fact. They're an unnecessary point at this point in time.
Thank you, Commissioner. I think we may be ready for a motion.
I can present that. I move that we adopt the administrative law judge's proposed order with the following changes. Amend finding of fact 3 based on the ED's exceptions and agreed to by the ALJs to read, quote, "The unclassified receiving water uses are limited aquatic life use for the unnamed tributary and Menkins Branch, intermittent with perennial pools, and high aquatic life use for Menkins Branch, perennial," end quote. Amend finding of fact 51 based on Jonah's exceptions and agreed to by the ALJs to read, quote, "The proposed facility and its discharge are partially within Jonah's district boundaries and wholly within Jonah's water CCN area," quote. And delete findings of fact 53 and 54 as unnecessary to the Commission's regionalization policy consideration in this case. I further move that we issue new TPDES permit number WQ00158-78001 to Air W 2017-7LP as recommended by the Executive Director, and finally adopt the ED's response to comments.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Well,
Motion carries. Ms. Smith? We heard you, Commissioner Lindley.
okay, good. I actually was going to ask if we could take a 3-minute recess real quick.
Let me just finish what I have to say about this. The motion, I guess maybe I did. The motion carries, and let's do that. Let's take a 3-minute recess. The time is 10:36, and we'll reconvene. Why don't we call it 10:40? Thank you. We are in recess. We're back after a short recess, maybe not so short. Time's 10:41, and Ms. Smith, I'll ask you to please call the next item.
Item number 4 is the application by Graham Vikas Partners Incorporated for new Texas Pollutant Discharge Elimination System Permit number WQ0015999001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
For the benefit of those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases on this type of application. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case, and assuming that at least one has done so, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. In determining who is an affected person, we consider the requester's statement of their personal concerns and their proximity to the regulated activity together with the nature of the proposed activity. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant to the application. And colleagues, on this item, we have 7 requests, 5 from individuals, 2 from associations. Let me begin with Ms. Allen. I agree with the executive director and OPIC that given the distance between Ms. Allen's property and the proposed facility, that she would not be adversely affected in a manner different from the general public. That is particularly true, in my view, on this application because of the relatively small discharge from the system. Turning to Mr. Evans' request, it does not explain how he personally would be affected by the proposed facility, so I don't believe he's demonstrated affected person status. The remaining individuals all fail to identify any issues at all, so we have to deny their requests. As for the 2 associations, I agree with the executive director and OPIC that they have demonstrated standing. The applicant zeroes in on whether the purposes of the associations are germane to the issues raised in the application, but I think that slices the analysis a little thin. I do believe the purposes are germane. So that's how I came out on the affected person analysis. Commissioner Lindley, how'd you come out?
I'm in agreement.
Commissioner Janeka.
Likewise, sliced right along the same line.
All right, turning to the issues, I think the associations preserved, properly raised, and for referral, the following 7 issues: whether the draft permit is protective of water quality and the uses of the receiving waters, whether it is protective of the health of the requesters and aquatic and terrestrial life, whether it adequately addresses nuisance odors, whether it includes adequate provisions to protect the requesters' use and enjoyment of their property, whether it complies with applicable anti-degradation requirements, whether it should be denied or altered based on need, as contemplated under Section 26.0282 of the Water Code, and finally, whether the information in the application is accurate. And colleagues, I would also include an ADR referral on this one, given the small number of parties, but I would allow the full 180 days for the proposal for decision. Commissioner Lindley, your thoughts?
I'm in agreement on the issues, the ADR referral, and the timing of the hearing as well.
Commissioner Janeka?
Likewise.
I think we're ready for a motion.
I will attempt, but I apologize. A yard man just showed up. If it gets rather loud, someone wave. But with that, I would move that we grant the hearing request of the Greater Edwards Aquifer Alliance and Texas River Protection Association, that we deny the remaining hearing requests. We refer the matter to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of water quality, including nutrient limits and excessive growth of algae, groundwater, and uses of the receiving waters in accordance with the Texas Surface Water Quality Standards. B, whether the draft permit contains sufficient provisions to protect the health of the requesters and aquatic and terrestrial life. C, whether the draft permit adequately addresses nuisance odors in accordance with 30 Texas Administrative Code Section 309.13E. D, whether the information in the application is accurate. E, whether the draft permit complies with applicable anti-degradation requirements. F, whether the draft permit includes adequate provisions to protect the requester's use and enjoyment of their property. Whether the draft permit should be denied or altered in consideration of the need for the facility in accordance with the Texas Water Code Section 26.0282. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and that we specify the maximum duration of the hearing as 180 days from the preliminary hearing to issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. All those in favor say aye. Aye.
Aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which is items 5 through 29. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 5 through 29. The total assessed administrative penalties are $728,060, with $78,328 deferred, $194,407 applied toward supplemental environmental projects, and $455,325 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Emily Lindley, Commissioner Lindley, any questions?
No questions.
Commissioner Janeka.
Likewise, no questions.
Okay. Mr. Arthur, what say OPIC?
Good morning, Chairman. Thank you. OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. I do too, colleagues. I'm ready to move forward.
Did you want to recognize those who have signed in on this item?
Oh, interested persons. Sorry.
Yeah. I just note that on items 6, 9, 10, 12, and 19, we do have folks signed in and available for questions, but it sounds like maybe there are none. And then we had 2 people signed in who registered to address the commission but aren't here. So,
thank you for that, Ms. Smith. Colleagues, let me first ask you if you have any questions or comments. But as you heard, I'm ready to move forward if you are.
No questions, only to appreciate the presence of some of the attendees on some of those items. They were items I marked for an initial closer look and didn't have any questions for at the end of it, so I appreciate them being there.
Thank you, Commissioner. Commissioner Lindley? No questions. I think we're at a point where we may be ready for a motion.
I move that we adopt items 5 through 29 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
item number 30 is the consideration of the monthly enforcement report, and our executive director staff is here to present.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through September. There were 60 effective administrative orders issued, and of those, 3 contain supplemental environmental projects. These orders assess a total of $548,959 in penalties, with a payable amount of $400,305. $86,390 are to be paid for supplemental environmental projects. 910 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 378 enforcement action referrals have been received. There are 2,182 pending administrative orders with 647 cases that are on the backlog. 193 cases are pending at the Attorney General's office for representation in district court. 2,141 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2021, 2022, and 2023. We are available to answer any questions you may have.
Thank you. I have none. Colleagues, any questions?
None,
Ms.
thank you.
Smith, is anyone signed in?
No one has signed in.
Mr. Arthur?
OPIC appreciates the report and has no comments at this time.
Thank you. I do too, and no action is necessary on this item. So Ms. Smith, when you're ready, please call the next item.
Item 31 is the adoption of the 2015 8-hour ozone NAAQS emission inventory SIP revision for the El Paso, Las Cruces, Texas, New Mexico non-attainment area. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Allison Stokes with the Air Quality Division. With me today is Contessa Gay with the Environmental Law Division. For your consideration today is the Executive Director's recommended 2015 8-hour ozone National Ambient Air Quality Standard Emissions Inventory State Implementation Plan revision for the El Paso County portion of the El Paso, Las Cruces, Texas, New Mexico non-attainment area. The SIP revision satisfies the Federal Clean Air Act Section 172C3 and 182A1 emissions inventory reporting requirements for the El Paso County, or for El Paso County, for the 2015 8-hour ozone NAAQS. The SIP revision also includes a certification statement to confirm the emission statements and non-attainment news source review requirements have been met for the El Paso County area. Staff respectfully requests adoption of the SIP revision. Thank you, and we're available to answer any questions.
Thank you, Ms. Stokes. I have none. Colleagues, any questions?
Not a substantive question other than just to note that I did observe the comment that ED staff provided a response back to the comment about the 179B demonstration regarding the same airshed attainment and how that is not relevant to the order before us today. I appreciate that that's really where the weight of the arguments are going to reside in this matter with EPA, so I'm interested and hope to continue to get updates from staff as they work on that issue, but I appreciate the matter as it is before us today.
Thank you, Commissioner Janeka. Commissioner Lindley, any questions?
No, I've got a motion if there's no more questions as well.
I've got to get over just a couple more steps here. Let's check for interested persons.
Okay.
None.
And Mr. Arthur, what do you think?
OPIC understands this SIP revision is needed to submit marginal non-attainment planning requirements for El Paso County to EPA by December 30th. We appreciate the clarification regarding the applicability of 30 TAC Section 116.150E and staff's commitment to clarify with rulemaking. OPIC supports adoption of the SIP revision.
Thank you, Mr. Arthur. I don't have any issues with this SIP revision. Commissioner Janeka, I think you're right. There's lots of issues swirling around this topic, but what's in front of us today, I think, is rather straightforward. And if there's nothing else, I think we may be ready for you, Commissioner Lindley.
Yeah. Apologies, Garrett. Sorry about that. But with that, I would move that we adopt the 2015 8-hour Ozone National Ambient Air Quality Standard Emissions Inventory State Implementation Plan revision for the El Paso County portion of the El Paso, Las Cruces, Texas, New Mexico non-attainment area as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
The next items are for closed session, and the commission will meet in closed session in Building E, Room 211S at, should we just say
11?
11? At 11 a.m. as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items number 32 through 35 as posted and noticed.
The time is 10:56. We are in recess.
The commission met in Building E, Room 211S for closed session from 11:01 a.m. until 11:14 a.m. on item numbers 34 and 35 as posted and noticed pursuant to Texas Government Code, Section 551.074. No action was taken. The agenda stands adjourned, and the time is 11:17.